into like a tragic accident on your way to work, is your employer legally responsible to compensate your family?
Well, most people would instinctively say no, right? I mean, you aren't on the clock yet. But a landmark 2025 Supreme Court case just totally blew that assumption out of the water.
It really did. So today in this deep dive, we're looking at Daivshala v. Oriental Insurance. It's a ruling that, well, it completely rewrites the rules of the daily commute.
Yeah. And to understand why this matters so much, we have to start with the human reality behind the paperwork. Back in 2003, there was this man named Shahu, and he was working as a night watchman at a sugar factory.
Right, and his hours were just brutal. It's 3:00 a.m. He's riding his motorcycle to his shift just 5 kilometers away from the factory gates when he is tragically killed in a road accident.
Yeah, leaving behind his widow, Daivshala. And what followed was just this grueling 2-decade-long legal battle against the insurance company over financial relief.
Okay, let's unpack this. Because the whole conflict basically boils down to one conceptual question. Does your job legally start the moment you leave your house? Or, like, only the second you walk through the physical office doors?
Right. So historically, insurance companies leaned really heavily on a strict 1996 precedent. And that precedent said commuting accidents were purely personal risks.
Which makes sense on paper, I guess.
Exactly. But to rule in Daivshala's favor in 2025, the Supreme Court had to completely dismantle that precedent. They leaned into something called the Theory of Notional Extension.
That sounds like extending the boundaries of the workplace, like an invisible legal umbrella. So the moment you step out your front door and begin your direct commute, that umbrella opens up and covers you, even before you officially clock in.
Oh, that's a perfect way to visualize it. The legal duty extends way beyond the physical gates. But to actually apply that umbrella, the court used the doctrine of Pari Materia.
In Pari Materia?
Yeah, it essentially means taking two laws with the same social purpose and, well, reading them as one cohesive text.
Okay, walk me through how that actually works, because the judges can't just mash laws together whenever they want, right?
No, they definitely can't.
Yeah.
But in this case, the ESI Act and the Employees' Compensation Act are like twin siblings. They share the exact same DNA of protecting vulnerable workers.
Got it.
And the ESI Act had a specific pro-worker rule, Section 51E, that explicitly covered commutes. So the court realized they could legally borrow that rule to fill the gap in the Compensation Act.
Wait, hold on. I was looking at the timeline here. That helpful commute rule, Section 51E, that was added to the law in 2010.
Right.
But Shahu's accident happened in 2003? I thought applying laws backward in time was explicitly illegal. How did they get away with that?
So what's fascinating here is how the court weaponized these doctrines specifically to protect vulnerable families. They used the principle of a retrospective declaratory statute.
A what now?
A retrospective declaratory statute. Now, usually, you can't change the rules mid-game. But a declaratory statute is different. Think of it like a referee reviewing a replay.
Okay, I'm following.
They aren't inventing a new rule. They're just clarifying what the rule was supposed to be all along.
Ah, I see. So the court is saying the 2010 amendment didn't create a new right for workers. It just cleared up an ambiguity about a protection that had theoretically been there the whole time.
Precisely. Because it was merely clarificatory, it was allowed to apply retroactively, which saved a claim from 2003 and finally got Daivshala the compensation she fought 20 years for.
Wow. That is a massive shift. I mean, it completely changes the balance of power, proving the law can actually act as a vital safety net rather than some technical trapdoor waiting for you to fall through.
The real-world ripple effects are huge.
Yeah.
But, there's a catch for the general public. Known as the nexus test.
The nexus test.
Yeah.
Okay.
Yes, your commute is covered under that notional extension, but you must prove a direct, unbroken connection between the time, the route, and your job.
Meaning, if I take a personal detour to buy groceries on my way to the office and get into a crash, that connection is broken. I'm not protected.
Exactly right. The route has to make sense for the commute. Still, for legal professionals, this judgment is an absolute masterclass in cross-statute interpretation.
Yeah, definitely.
It provides a really clear blueprint for using clarificatory amendments to bypass strict precedents against retrospective application.
It really shows everyday workers that they have protections they might not have realized. We started by asking if your employer is responsible for your commute, and this case proves that, well, under the right conditions, that invisible legal umbrella really is there.
It really is, and it sets us a fascinating precedent for the future of work.
Which leads me to one final question for you to mull over. Since this entire ruling relies heavily on the physical nexus of time in a specific 5-kilometer route, How might courts eventually have to adapt these exact same protections for remote workers? Like, if your commute is just walking down the hall to your home office and you trip, does that invisible legal umbrella open up inside your own house?